may I pray for my lord, day after tomorrow, my lord, on Thursday, my lord. 17, Thursday. What number? 18. 47. 47, my lord, supplementary. Abdul Salam, my lord. Okay. Similar prayer, my lord, regarding item number 17, my lord. It may be listed tomorrow, my lord. Zahirul Islam. Item 17, regular Islam.
Borua, so tomorrow it will be difficult because it's not before us.
Yes.
Even if you send it, it will be late in the evening. So why not list tomorrow?
Day after tomorrow, my lord. Obliged.
May please, Lordship, I beg to mention item number of today's list, Lordship. Item number 8, Lordship.
Party's name?
Participant Bipul Dasgupta, Lordship.
Yes.
Lordship, in this matter, I need to have a little accommodation till Friday, Lordship.
Eight total list. Okay.
May I please, Your Lordship? I beg to mention for listing in criminal petition on 3rd of September because both the parties have given same case in different petition and they have been amicably settled. On 3rd of September.
Okay.
Obliged.
May I please, Your Lordship? I beg to mention item number 48 and 49, Your Lordship, from court number 18, Your Lordship. It was anticipatory bill application, Your Lordship. I am not on interim, Your Lordship. Kindly day after tomorrow, Your Lordship.
May I please, Your Lordship? The part had metal Lordship criminal division. On last occasion, I had mentioned for today, but didn't come, Lordship. Lordship, day after tomorrow possible, Lordship.
Saturday.
Saturday, what is it? Lordship.
May please, Your Lordship, in court number 18, Lordships, item number 25, 28, 29, list day after tomorrow, Lordship. Twenty-nine. 25, 28, 29.
Okay.
On 29, deployed. Item 20 and 21, Lordship. Item 20 and 21, Lordship.
Which code?
This court number 3, Lordships, original court, Lordship. This file is misplaced from our chamber. I'm seeking for 15 days time, Lordship. 20 and 21.
We are not 20.
And 21.
We are not passing any order at this stage, okay? Let a matter reach. We'll ask someone to be here at this because these are of 2013 matters.
Lordship.
We'll not pass any.
So another mention, Lordship, I am listing the matter for orders, Lordship. For the day after tomorrow,
Friday.
Friday, obliged.
May I please, Your Lordship? I beg to listed on criminal petition 870 or 24, Lordship. The matter may be fixed next week, Lordship.
When it was last listed,
Last listed on 12/8/2024. 12/8.
before this court. Before which court?
Before court number 18.
For orders on 30th season. Yes.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 25 for withdrawal. It has come up for hearing. The appellant has already expired.
Madam Kechi, just wait for a few minutes. As soon as the mention is over, we'll take care of it.
Please, Your Lordship, I beg to mention item number 23. Matter is infrastructure, Lordship.
Matter is under NIAC lordship. Entire money is received by the appellant lordship.
Where are the documents? Where are the documents?
I think it's not received. Yes, send of WhatsApp.
At
lordship.
least to see, for that purpose, you have to place it something before the court. Simply on the submission will not do. Yes,
I beg to mention listing of a bail matter in bail hearing. The matter was to be listed on last week, but it has not been listed.
from which police station?
Why?
When it was moved?
Hmm?
When it was moved? What was the last order?
No. Last week.
What was the last order?
No, last week.
Verify and tell us. Yes,
I beg to mention a matter for listing for orders, my lord. IA, my lord, condonation of delay, my lord. Also may come even on Friday, my lord.
Saturday.
Saturday. Always when.
May please the lordship. Lordship, I have some urgency, lordship, in advance of the code number 18. Item number 34, lordship.
Hmm.
Lordship, if possible, lordship. Lordship, in this case, lordship, today's 5th day, the city is not come and the lordship, police, NCB persons are is searching. Today morning also searching, lordship. So I may be arrested any time, lordship. Otherwise, my bail petition will be infructuous. And today's 5th day, lordship.
This is from which police station?
Lordship, it is NCB case, lordship.
Okay.
What
Yes.
yes,
Who appears?
lordship, Mr. Kyle. And his juniors, lordship, I already informed lordship that I am going to mansions.
Okay, we'll take up at 2 o'clock.
I'll have less.
Lordship, I beg to mention item number 38, 39 and 40 of code number 18's list, lordship.
Hmm.
May be taken up in the second week of September, lordship. So all pending.
Maybe inform the other side.
Yes, lordship. It's a all pending matter, which is why, lordship. You are for the respondent, lordship. Stay order is there, trial is,
Then why do you want to, anyway?
lordship. Stay is there. Since 2013, lordship, it was stayed, lordship. We have filed a petition for vacating the stay also, lordship. It was fixed for hearing.
5th.
Lord, some more matters are there on first week of September.
12th.
12th, lordship. Right.
And the of the conscience of the circuit, including this condition sincerely. ಈ ಬರುವ ಕಥಾಮಿತಿಗೆ ಅನುಗುಣ ಕಥಾಮಿತಿಗೆ ಅನುಗುಣ 34 ಆರ್ಡರ್
If the person has died, then abated, but I don't have any instruction. Is he in jail?
No, he was under order was suspended. For conviction was suspended.
Do you have the death certificate? with you?
Lordship, I do not have that. So it's been some 3-4 years back. I did not get the date also. I could not get the date also. But my instruction is that he has passed away some 3-4 years back.
I can get an instruction from the superintendent, but he was on bail, I'm told, but then still he'll have, even then he'll have.
Dowry death.
You mean? B Sharma?
Or MS MKG, council appearing for the appellant. And MS as Zahan Lani, additional public prosecutor. Appearing for the state. The appellant hearing. Namely Ranjoy Sohan. Son of Bikram Sohan. Resident of New Port Road. Police Station, Tinsukia, District Tinsukia. Was convicted by the learned session judge. Tinsukia. In sessions case number 57, opening bracket P/2010. Arising out of Tinsukia Police Station case number 359 of 2008. Opening bracket D. Yujuburi POP GD entry number 174 dated 08/06/2008. Under section 304B IP3. With 7 years of rigorous imprisonment. And under section 4. And rigorous imprisonment for 6 months with fine of rupees 2,000. In default, RI for 1 month. For the offense under section 4 of the Dowry Prohibition Act. Because of the death of his wife, Deepa Kumari Mahato. Agree with the said judgment of conviction and sentence. I would say it will recommend 0.25. 0409/2013 of learned session judge. The said convicted accused preferred this appeal. On 30/09/2013. And the court, while admitting this appeal, this statutory appeal, and suspended. And by order the 07/10/2013 suspended the sentence dated 04/09/2017 imposed of everything by the session judge in said sessions case number session judge. Ms. Keshi, on instruction submitted in that. In the meanwhile, during pendency of this appeal, the appellant Ranjoy Chauhan had expired. Based on
a short date, I'll get a telephonic instruction.
10th,
I'll get a death certificate also. 10th
10th of
September.
September. Enabling Miss S. Jahan, Lorry Additional Public Prosecutor, to place relevant instructions with regard to the
I'll have to.
review instructions from the
They will have now forever. Okay. Can I have this?
officer in charge of the Interior Police Station within the and the superintendent of police relating to the death of the appellant Ranjay Chauhan, son of such and such, resident of such and such. Resident of Kijuguri, Mokois. Ranjay Chauhan, son of Vikram Chauhan, resident of Newport Club.
Of life. Keep your picture.
May it please your lordship. I apologize for the delay, your lordship. There was a matter listed in court number 18, your lordship, item number 32. The person is behind bars for 55 days. I want to withdraw the case, your lordship.
55.
32, your lordship, of court number 18. I want to withdraw the matter.
File to Loewe. This is from which police station?
This is CBI case, your lordship.
Since in custody since when?
55 days.
Can you give us the date? Give us the CBI case number and the date.
Yes, sir.
32, no? 32 years.
Or Mr. P. Diddy and counsel appearing for the petition. And Mr. M. Halloween standing counsel CBI for the sole respondent. On instruction of the petition. Non to the ready. Mr. David and counsel is not pressing this bill application. To which Mr. Howell and counsel started sending us a no objection. Petition since dismissed is not dismissed. Okay.
29/6/2024, I was arrested, your lordship.
Case number,
RC, capital RC 0172.
just a minute, RC 01.
Yes, sir. 7202 4A 4 capital A, your lordship. 0002/2024. Under section 7 of the Prevention of Corruption Act 1988, your lordship.
Okay.
I'm deeply obliged, your lordship.
Councils are not here. 2013 matter. Period. Admission.
Leave again, this is an appeal against acquittal.
Acha.
Normally Asnaf appears.
It's a long pending matter. Perhaps something had happened in between. It's an appeal against acquittal only.
Today we will not pass any order.
Lordship.
Yeah, very good. Problem you have to maintain, all right? Necessary. Issue, necessary.
Wait, that's not. That's not.
Money become.
It could be. Could be.
মানে কিয় কৰে না সদায় বাৰে বাৰে এটা কথা বুৰুৱাই পেলাই কিমান আহিব কিমান মাতিম চেম্বাৰত সেইটো কথা কি হয়
P. Chaudhary. 2013 আমি ভোট পুরনো আমি।
এই বস্তুবিলাক কিয় হৈ আছে উচিত নহয় registration legislation matter of the name of Mr. SSM, people sorry. Then Mrs. Also SHAMG, Mr. A7, and MS F. Khan. Along with the public particular sound. No, for the response number 2, along with public prosecutor for the state responded about this. People if you want to. ইয়াৰ পিছত আৰু ইয়াতে গালি ধৰিব লাগিব আৰু ঠিক আছে মেম আজি দুপৰীয়া মোৰ তাতে দি থওঁ ৰেজিষ্টাৰ জুডিচিয়েল
Yes, Mr. Goro. Yes, Lordship, this is a petition. I must say that senior counsel Detkamar is an ideal for a partner matter, therefore I'll pick this up. Lordship, this is a petition challenging an order in special case 6/2012. 1/10/2019, Lordship, at page 46. It was a petition for clubbing of the case, keeping in abeyance of the cases in regards to S1010 has already been kept in abeyance. Lordship, firstly, I wanted to point out that there is earlier order of this court that there is no stay order regarding 1010 or 610. Lordship. Now, Lordship, while going through other cases, I could find out two orders. Lordship, I'll place it beforehand. That I do. Lordship, in a petition challenging the FIR, which culminated into special case 1010, the Honorable Court, in view of a writ petition pending, has made signed dialogue. Secondly, Lordship, I'll just read out the order of the impugn order for a moment. May I read? Lordship? By this order, the court proposes to dispose of the petitions, namely petition number 512/2018, 730/2019, 774/2019, filed in the case. On the last date, the court heard the counsel of both the sides. For petition number 5112/2018, it is seen that by filing the petition, the accused person, namely Amjad Hussain, and Ridaul Hussain Khan, have prayed to keep recording the evidence or witness of the case in abeyance, and also prayed for a joint trial by clubbing the case record with special case 1010 and trying both the cases in a single trial as per provision of 223. To dispose of this petition, we take recourse to the orders of the special case 1010. In case record of special case 1010, the accused person, by filing a petition of similar nature, has prayed for amalgamation for joint trial of special case 1010 and the instant case special case 612. From the record, it is seen that on 2 occasions, the court, with respect of special case number 1010, by the order dated 1/1/2016 and 19/9/2016, by rejecting such prayer, has ordered for simultaneous trial of both the cases by clearing the matter that there will be no amalgamation of both the cases, but case will be disposed of on the same day. It clearly shows that the such prayer of clubbing together both the cases of the accused person and the same stood rejected, and the accused person has not challenged the order in the Honorable Supreme Court. Therefore, Lordship, first thing is that though the clubbing of petition of 1010 and 612 was rejected, but it was by the 2 orders mentioned that both the cases will be heard simultaneously and disposed of on the same day. It clearly showed that these orders attain finality, it cannot be reopened now. As such, the prayer made by the accused person in this petition has no merit and stands rejected. Proceeding further, we have seen that the Amjad Hussain have moved another petition, namely 730, wherein it is stated that his counsel filed a petition so and so along with copy of the order dated 21/5/2019 in criminal petition 334/2019 passed by the Honorable Guwahati High Court, wherein a prayer was to keep in abeyance the proceedings of this case and the special case 1010 till disposal of the criminal petition number 334 pending the Honorable Court in special PMLA case 3/2018 for needs of justice. It is submitted that learned counsel for the accused that dated 31/7/2019, the court in special case number 1010 allowed the prayer made by the accused. Now the accused has prayed to admit this petition and keep in abeyance the proceedings of this case on the strength of the order passed in special case 1010/2019. Upon going through the case record, the special case number 1010, it is found that that on 31/7/2000, the prayer of the accused to keep in abeyance of the proceedings was allowed. But in fact, there is no such order made by the Honorable Court in PMLA 3/18.
Yes, Mr. Haloi, what do you have to say?
Lordship, they filed this petition simply to reject the order passed by London Trial Court, Special Judge Court, that is on 1/10/2019. The order clearly reflects that there is no illegality, Lordship. They have shown an order of this honorable court wherein they have challenged the legality and validity of the FIR and charge sheet. For quashing of the charge sheet and the quashing of the FIR, they have filed a petition, criminal petition before this honorable court. And this honorable court, after hearing, had stayed that order in the PMLA case, not in CBI case, Lordship. So therefore, there is no illegality in this order, Lordship.
But what I wanted to point out is the last part of the order. The reasons for rejecting, Lordship, I will just throw and place an order of this court. Lordship, may I at page 47? Because the CBI cases all emerged from the NIA case. In the NIA case, I have been already honorably acquitted, Lordship. That is not on record in this case. Lordship, may I read the last part for once? Upon going through the case record, special case number 1010, it is found that on 31/7/2019, the prayer of the accused person to keep in abeyance the proceeding was allowed. But in fact, there was no such order is made by the Honorable High Court in PMLA case 3/18 for keeping in abeyance the trial. Lordship, in 3/18 has already been stayed by this court in criminal petition 334. This is the order, Lordship. So, moreover, Lordship, there is already orders that both the trial will be conducted simultaneously and both will be disposed on the same day. Now, 1010, Lordship, I have already given an order in WPC 5373. 1010 has already been made signed die. If there is already an order that both the cases will be disposed on the same day, the CBI has not challenged that order. Lordship, at the first part of the case, Lordship, the Honorable Trial Court has referred to two orders, which though they have rejected the amalgamation of the cases, but they have said that it will be conducted simultaneously and disposed of on the same date, Lordship. Lordship, 10th line onwards. Two orders. Therefore, by order dated 5373, which I have already placed, the 1010 has already been kept in abeyance and made signed die, Lordship. If both the cases have to be disposed of on the same day, then this case has also remained, Lordship. And another ground for rejecting my prayer was that there was no stay order from this court in PMLA case 3/18. But Lordship, in 334, on hearing the parties, it is directed that all further proceeding of special PMLA case 3/18 be stayed till the next day. Therefore, the prayer was very bona fide, Lordship, and moreover, these CBI cases emerged from the NIA case, Lordship. NIA case, I have already been acquitted, Lordship. Lordship, if Lordship allows, I will bring every order on record, Lordship. And there is no stay order. Lordship has already indicated earlier that they want to conduct the trial where there is a stay order. There is no stay order. The Honorable Trial Court can very well go ahead, Lordship. There is no stay order as such.
My lord, may I, Lordship?
Yes.
Lordship, my learned friend has rightly stated that the CBI cases arises out of NIA cases. Admittedly, it is. But the purpose of NIA case and CBI cases are completely different. CBI cases dealing with the corruption, Lordship. It is a corrupt practice of the public servant by which they have siphoned off crores of rupees. 13 crores of rupees has been siphoned off from the Department of NCL Autonomous Council, Lordship, various departments, Lordship. It is a completely separate chapter, Lordship. So, Lordship, CBI on the basis of that, those FIR, Lordship, now carried out investigation and registered these two cases, which was before the trial court. Lordship, now they have filed a petition that subsequently PMLA case has been registered and PMLA was stayed by this honorable court. And on the strength of this PMLA case, now they are praying that these two cases should be. The PMLA cases, CBI cases are also different, Lordship. The Corruption Act, PC Act, and the PMLA Act, the object and purpose of these two acts are different, Lordship. We are handling with the corruption cases, Lordship. PML, until and unless, Lordship, there is no corruption, PMLA cannot be come into existence, Lordship. So therefore, the corruption cases must be first handled, Lordship. It must be tried. And thereafter, Lordship, the PMLA. Until and unless there is no existence of these corrupt cases, Lordship, corruption cases, the PMLA cannot come into play, Lordship. The corruption, Lordship, it's, if your Lordship see the Act, Lordship may kindly have a look into the Act, Lordship, PC Act, Lordship. The object, Lordship, of the PC Act is to prevent the corrupt practice of the public servant. 44 to that apart, Lordship. The PMLA specifically states its object, Lordship, in the very first beginning of the Act, Lordship, an act to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering. So what is money laundering has again been defined under this Act, under Section 3 of the PMLA Act, Lordship. What Section 3 says is, Lordship, offense of money laundering, Lordship. Whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly is a party or is actually involved in the process or activity connected, proceeds of crime, including its concealment, possession, acquisition, or use, and projecting or claiming it as untainted property, shall be guilty of the offense of money laundering. So here, Lordship, it is very clear, Lordship, it is with regard to the possession, concealment, acquisition, or use of projecting or claim of the property which is acquired, Lordship. So, Lordship, the object of PMLA is completely different with that of the PC Act, Lordship. PMLA deals with the proceeds of the crime, whereas, Lordship, PC Act deals with something else, Lordship. It is an act to prevent the corrupt practice of the public servant, Lordship. Though, Lordship, the corruption has not been defined in the Act, but in simple terms, it's a, Lordship, it's an act of a public servant which has been influenced for any monetary gain or for any other consideration, Lordship. That is corruption. And, Lordship, in this petition, Lordship, they have challenged the order. There is no irregularity, Lordship. These honorable courts on a particular that has kept the in cyanide, Lordship. Subsequently, this matter has been mentioned, and again it has been taken up. And the purpose of all those cases which has been tagged, Lordship, completely different. Those are ED cases, Lordship. We are not a party to those cases, Lordship.
Lordship, my point
That
is.
apart, Lordship. Lordship. Lordship, by showing various fringe reason, Lordship, they have misguided this court, Lordship. There is no stay order in the PCX case, Lordship. Neither in
Come to the 8 lines of second paragraph.
To dispose this petition, we can take.
Then you come to the next line. In case record,
Yes, Lordship.
from the case record.
In case,
From the record, it is seen.
in case record, special case number 10/10.
In case record, special case number 10 of 10,
Yes.
the accused person. by
The
filing case.
accused by filing a petition of similar nature has prayed for amalgamation of joint trial of special case 10/10 and the instant case 6/12. From the record, it is seen that on 2 occasions, this court with respect to special case 10/10 filed order dated 11/1/2016 and 19/9/2016 by rejecting such prayer has ordered for simultaneous trial of both the cases by clearing that the matter will be no amalgamation of both cases, but case will be disposed of on the same day.
What do you understand by this line?
Lordship, Lordship, what, to my limited understanding, Lordship, what it means that though it will not be amalgamated as a joint trial under 223, the both case will be heard on the same dates
Where is
and
that?
disposed of on the same dates.
It will be disposed of on the same date.
Yes.
Maybe hard on the different dates. It may be disposed of on the same date.
Lordship, simultaneous,
Let her say,
Lordship, simultaneous, to my,
where is that finding of the learned trial? Learned
Lordship,
trial court?
these two orders I have asked for the
No, no,
certified
that
copies.
is why we are asking you. Where is that finding that there will be simultaneous trial?
Yes, Lordship, these two order I have asked them, Lordship. The order sheet I have asked of these two orders, Lordship. I have,
Mr. D. Bora.
Lordship, before passing, I have something to say, Lordship. For last 13 years, Lordship, trial is pending. Please, let me read.
it's
Trial is
2019
pending, Lordship.
order.
Witnesses are expiring, Lordship. One by one, witnesses are expiring, Lordship. Even accused. The whole purpose of the investigation and trial will be frustrated, Lordship. If it
Okay,
continues.
do one thing. Mr. Bora, give your written submission by the afternoon. Mr. Haloy, make your written submission.
Lordship.
Please this matter on.
Third, Lordship.
We have heard it. We were passing. 29.
Can it be on third, Lordship?
Sorry. Mr. Haloy, I'm sending out. Please the written submission.
Hello. Hello.
In this case,
Yes, where is that affidavit, John affidavit?
we are filing the affidavit. We have filed affidavit, my lord.
Where you filed?
That was filed, my lord. It was filed last week, my lord.
It's not before us.
But in the system, it has shown, my lord.
Bora.
Kita file problem.
No joint affidavit. 21st, the office note clearly mentioned, no joint affidavit.
But we have filed it, my lord, in the system, they are showing that it was filed. Additional affidavit filed on 17/8, my lord, in the filing section, my lord.
Mr. Kotiki, you will have day after tomorrow.
Yes, madam.
List on. Along with.
A copy for some reason. Yes. We have already supplied copy to them.
The additional affidavit.
It's not really.
It's an additional affidavit by both the parties
Or
or
by the petition. By the petition. Your lordship has asked for the order passing the GR case, PRC case. That was also enforced. Order by Q20. In pursuance of the agreement.
filed by the petition on 17/08/2020. Please this matter certainly it's allowed to. ভিতৰত দিব আগৰ কেছটো ভিতৰত দিব আগৰ কেছটো ভিতৰত দিব অলপ ঠলাই দিব লাগিব Admission fees is like, it is hundreds of the consider. Item number 4.
Lordship, the conducting counsel of this matter is out of station. His name is reflected in the advocate leave note. Lordship, the matter may be taken after one way.
Lordship, I perused the loss order. They were asked to provide the instructions regarding the statements.
Who appears for the respondent?
Ishani Shah. The conducting counsel, Mr. A.W. Aman, is out of station, Lordship.
You said his name is there in the.
Advocate leave note, sir.
Okay, we'll have it on 38 or 27 and 28, so we'll have it on 29th.
29.
The counsel for the respondent of the AW is out of station. By filing leave application, list on 29.
My lord, if possible, on 2nd of September, my lord. 29th, there would be some difficulties, my lord.
Part of September.
Obliged.
Oh. Actually, Yes, you're supposed to have the report. You have the report from.
Why to see whether vehicle is equipped, vehicle, no.
Last.
I remember.
There was a verbal instruction.
Oh, Lordship wanted a written instruction. Yes, Nandita Das had sent the had sent the information. Lordship will take it up after some time. I'll speak to Nandita Das. She, in fact, she told them to send a written report. Nandita Kuchu? Because I had taken a verbal instruction and they said that they don't require.
Matter relates to mobile phone.
Yes, mobile phone.
Mobile phone.
Get the information, we'll have in the second half.
Lordship. Lordship will take it after some time.
We'll have in the second half.
Lordship.
At 2, my lord.
Lord, it may be taken after some time.
Who is appearing for the other side? Not appeared.
Some K does appears. It's for number 1. And he has also filed an affidavit in opposition in criminal petition.
The justice shall reflect the name of Mr. Konkondas, KNKN.
K Das is reflected,
Already there.
And
but not the entire name.
Sazahan Ali, SHAJHAN. Learned counsels for the rest number in the cause list. Along with the public prosecutor, Assam. That's one number 2. And the respondent columns against this item in the cause list. List on.
No, my lord, first week of September.
The complainant wrote it to the additional DCP. That was actually not required.
2nd of September.
Obliged. May I please to my lord?
This is regarding the confiscation of vehicle. Do you have the report with you, ma'am?
Yes, my lord, it's regarding.
We're
Report
asking you,
I,
Ms. Zahan,
Lordship.
Ms. Das appeared again.
Yes, confiscation she was supposed to ask. Confiscation to?
Okay, we'll take it up in the second half.
Lordship, yes.
We'll take it up.
Confiscation. I will do it.
We'll take it up at 2, Mr. Deori.
My lord.
Someone mentioned in the morning, question, please read your case too.
Oh. Yes, 34 have gone through. That's 6 number of cattle, as I was saying. This lordship will get a transport of animal goods.
No, in the morning, somebody asked for it, some prayer was
In respect of item 34.
34 of this. Anyway, yes, right, that the 6,
6 cattle, lordship will get it in transport of animal rules. If your lordship has that big book, I mean, on their lordship will get the rules made under the main act of 1960. The yes. Transport of animal rules, lordship will go to transport of cattle. There are different categories mentioned. Transport of cattle, lordship will go to chapter 4. Of course, things are not that, I mean, I find a little difficulty here.
Which rule?
Rule
56.
46, it starts from 46. And the concern, the
Transport of animal rules, right?
transport of animal rules, 1978. And transport of cattle starts from section 46.
Right.
Lordship will go to the relevant section, section 56, rules, rule 56. When the cattle are to be transported by goods vehicle, the following precautions are to be taken. Then lordship will go to C, clause C. No goods vehicle shall carry more than 6 cattle. And R is a case where trucks are seized. There are 2 trucks. One truck had 31 cattle and the other truck had 25 cattle. And Abdul Sattar is praying for Jimma of 31 cattle, which is there in one of the truck. And it says any goods vehicle, not more than 6 cattle.
Not ordinary goods vehicle, not any goods vehicle, ordinary goods vehicle.
Transported by goods vehicle.
Rule B, 56B.
Ordinary goods vehicle shall be provided. It doesn't matter. 56 talks of any goods vehicle.
The rule 50 has
Special-
provided special.
No, A says specially fitted goods vehicle with special type of tailboard or on padding around the side should be used. Ordinary goods vehicle shall be provided with anti-slipping material. That is a different clause altogether.
Right.
No goods vehicle. This comprises of all kinds. No goods vehicle shall carry more than 6 cattle. Each goods vehicle shall be provided with 1 attendant. So as far as the merit of the case is concerned, there is a violation.
What do you have to say, Mr. Supriya?
Lordships, I have
Yes.
rule 50, Lordships. Rule 50 provided some space. By the way, Lordship, I am not before your Lordship to classman or acquittal Lordship. I am for the Jimma Lordship. Jimma Lordships, I have already furnished 2 judgment copy of personalities honorable court Lordships. where is really covered by this case also, lordships. But if the kettle is kept in the Gusala, lordship, the petitioner have to pay the maintenance fees of rupees 200 per day, lordships. And if your lordship go by the section 29, lordships, section 29 of the Prevention of Cruelty to Animals Act, lordship, section 29 says that, lordships, the kettle can be confiscated only on the second conviction, lordship, not first conviction, lordship. Section 29, lordship. If there is a overloaded, lordship, then section 11A will be applicable. 11A punishment will be 50 rupees, lordships. If you lordship kindly see section 11 of Prevention of Cruelty to Animals Act, 1960. Section 11, lordship.
Yes.
Section 11A, lordship. Treating animals cruelly. One, if any person beats, kicks, overrides, overdrives, overloads, torture or otherwise treats any animal so as to subject it to unnecessary pain or suffering or causes, or being the owner permits any animals to be treated, or so and so, lordship, the punishment part, lordship will find it. He shall be punishable in the case of the first offense with fine which shall not be less than 10 rupees, but which may extend to 50 rupees. In the case of a second or subsequent offense committed within 3 years of the previous offense, with fine which shall not be less than 25 rupees, but which may extend to 100 rupees, or which imprisonment for a term which may extend to 3 months or both. And now your lordship may kindly see the section 29, lordship. Section 29 of the Prevention of Cruelty to Animals Act, lordship. Section 29, lordship. If the owner of any animals is found guilty of any offense under this act, the court, upon his conviction thereof, may, if it thinks fit, in addition to any other punishment, make an order that the animal with respect to which the offense was committed shall be forfeited to the government, and may further make such order as to the disposal of the animal as it thinks fit under the circumstances. Clause 2, lordship. No order under subsection 1 shall be made unless it is shown by evidence as to a previous conviction under this act, or as to the character of the owner, or otherwise as to the treatment of the animal, that the animal, if left with the owner, is likely to be exposed to further cruelty. That meaning that, lordship, the cattle cannot be confiscated unless it is proved that he has previously convicted, lordship. Even his first conviction, the cattle shall have to given to the owner, lordship. And I have also annexed the Supreme Court judgment, lordship, in my petition, lordship, the manager principal case. The section 35 of the Prevention of Cruelty to Animals Act, the main object of the cattle keeping in the Gusala is to treatment and care, lordship. For treatment and care purpose, the said cattle are kept in the Gusala, lordship. And that says section 35 has been interpreted by the Honorable Supreme Court, lordship. I have annexed in my petition, lordship, kindly see page 40 of my petition, lordship. The relevant portion you also will find at page 44, lordship, on my petition.
Where?
Page 44, lordship, paragraph 10 of the page 44 of my petition, lordship.
Just a minute, just. Just. Let's take your seat. Get back to you.
Lordship.
Yes, Ms. Jahan, probably your report will be required because this is an order sometimes of April 2022.
Hmm.
Now we are just end of August 24. Whether these things.
2 years.
Now
They
at
co-
that point of time, Jimma was rejected,
Hmm.
but by now we do not know.
Yes. In fact, I spoke to the IO and I told him to send the case diary. Perhaps he has sent it, I mean, individually in the office, or I can get a report as your lordship desires.
Yes,
No,
because these cows has been seized.
Hmm. Whether they are still alive or not.
Many
And
things have
they are there in the Pinjapur now, I think, no, where it is, Pinjapur. And of course, the decisions
I
that
have
he
doubt
has
like
cited.
this cattle are alive or not, Lordship.
So let me get a report then, and otherwise the judgments that he has cited. The Supreme Court says that yes, after seizure, the cows has to be first sent to the infirmary. They should be treated there. And after that to Pinjapur. And then while saying this, the Supreme Court said that the ownership as a owners have a preferential right.
Yes.
But then conditions are given. Lordship will see at page number 44. 44, the conditions are given when interim custody can be given. 44, Lordship will come to the middle portion of paragraph 10. This is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18 lines. In deciding, it starts with in deciding. In deciding, little Lordship get it? 18th or 17th line from the top, paragraph 10. In deciding.
Yes, in deciding.
Yes, in deciding whether the interim custody of the animal be given to the owner who is facing prosecution or to the Pinjra pole, the following factors will be relevant. The nature and gravity of the offense alleged against the owner, whether it is the first offense alleged or he has been found guilty of offenses under the Act earlier. If the owner is facing the first prosecution under the Act, the animal is not liable to be seized, so the owner will have a better claim for the custody of the animal during the prosecution. For the condition in which the animal was found at the time of inspection and seizure, there is violation here. The possibility of animal being again subjected to cruelty. Now, I mean, loading 31 number of cattle in one particular truck will definitely amount to cruelty.
It will decide by the veterinary officer, not by the IO concerned lawsuit, not by the legal counsel lawsuit. It is the duty of the veterinary officer, it is the duty of the IO to inform the veterinary officer immediately after seizing of the cattle lawsuit.
No,
Then lawsuit,
first-
the veterinary officer will examine as per the Prevention of Cruelty to Animals Act lawsuit.
Now that will come later. The very first stage that you cannot,
The moment the police officer will seize the animal, he will have to inform the veterinary officer.
doesn't matter.
Veterinary
That will
officer will examine the cattle lawsuit, whether it has been.
It is better you get the report.
not.
lawsuit.
Veterinary thing will come later. The carriage itself was
The
wrong.
moment the cattle is seized, the veterinary officer will.
The carriage itself was wrong. 31 cattle in one truck cannot. I'll get a report from the Nagaon, no? Oh, how many? How much of a Cayman cattle? I'll tell him to verify. Cayman cattle also. Oh, level.
Maintenance
Owner to খরচা দিয়ে আছে চাগে
অনেক খরচা আমরা সাথে কেলা করে দিতে হলো যাবে এটা 2 বছর দিন মানে এভাবে করে 50,000 টাকা পড়ে গেল
Very number. AS 01 FC 9575. Well, looks over found. Right in the legs. Right in the legs. An incident that took place on the night of 04/04/2022. At Jokula Bundha. Considering this, the officer in charge of the Palavanta police station is directed to submit updated status report of the Palavanta police station case number 47 of the 2022. And with regard to 31 numbers of cattle that were seized from the truck number, something such. List on 6th of September.
6th of September.
Copy of this order to Ms. Zahan.
of license.
This is chapter 7.
Kindly, the item may be adjourned for the day as the conducting council is out of station.
Who is the conducting council?
Mr. M. Along.
Hmm?
I am Along. For item 36.
Lordship wanted to know that Rajneesh Neha, what is the stage and what should be done?
We'll have it on Saturday.
Saturday.
Lordship, except Saturday. Saturday, except Saturday, any day.
Why Saturday is a working day?
Lordship, he will be out of station. He'll arrive by Sunday.
We have faced this case in his presence.
I've taken out judgment on recirculation and remanding. Few states have remanded.
Okay, on third.
Highly
Ms.
obliged.
Leclerc on third Tuesday.
Third, Lordship.
Lordship, we are suffering a lot.
We know that.
Saturday will not be there.
Yes, definitely.
Lordship.
Highly lodged.
Deeply
Highly
obliged, your
obliged.
Lordship.
I'll go request to There's another case, just previous case. I think that also relates to the same.
Thank you, Your Lordship.
Council is not present.
Acha.
কোনটা রেখে fix করবো?
That can be also listed together.
Third. Request complaint with this case and not a brief edition. Check the request. The other case you have fixed on fifth, it will be on fifth instead of third on fifth.
Lordship, fifth.
Lordship,
Fourth is a holiday.
yeah. Fifth.
Fifth.
Lordship.
Order number 38
Yeah.
from supplementary list.
37.
You want to make some prayer?
37 together it goes. Seventh. Oh, Eri. Fifth.
As per office code dated 21/8, LCR has been received.
Three to six. Here is the report of the register judicial. What's your good name?
HK Sharma.
As for the office note. There's a 21/08/2024. Records of CR case number 75756 of the 2017. Has been from the of the Court of London 163 comes MFC. From movement of party has been tagged along with this appeal. The registry shall reflect the name of Vishwadip Bora, URH. And Porimon Data. For the restaurant numbers 1 and 2. In the code list. List only. Sixth.
Much obliged.
Sixth, no? Fifth first.
Much obliged.
Recover, try to recover the server document at our chamber of support.
In this matter, we were, yes, we were supposed to bring the instruction as to the victim was served or not. Now, Ms. Nandita Das is absent today. My colleague is trying to contact her and get the information whether it was served.
Tuesday, next Tuesday.
Next Tuesday. John has a-
Third.
Third,
Third or
Lordship.
fifth, up to you.
Any day, third or fifth? Third. Third.
Okay. Third.
Obviously.
My please, Your Lordship. We have taken steps as per last order, Your Lordship, to the OC.
Yeah, approximately.
No, copyright.
Copyright. Did you have a cure lesson notice?
No, it's a political application.
Informant on. Who's the informant?
1999 or ever.
Lagi was an informant of.
Respondent to her.
Doesn't matter. Bella offense to
From
another.
Murlago police station, you are not getting a report.
Chip, I don't have it today, so I have a petition. Petition or not? No,
Okay, on fifth,
Lordship.
in pursuance to the order is the 31072024. The officer in charge of Borough Police Station shall submit this report.
FIR from court,
Copy of the order is
FIR from another.
31072024.
Forwarding. Whether it is. Whether it is required.
Be
Forward.
understood. Next time, Jahan, as Jahan, I will listen to the question of the foreign. So you can get a report on fifth. You have time.
Lordship, because what I'm trying to find out whether it is required respondent, otherwise order is there. This is,
Police, it was served.
Yes, sole and, no, whether informant, the presence of informant would be required in the present case. We beg to inform you where a sole and exit.
Lordship, an interim
Some
order is there.
incident-
Maybe continue.
Treat legal, sir. He is the police officer, I think. Nikki, no. Otherwise, it's for quashing of the order, FIR. Quashing of the entire proceedings.
Limitation of.
We are there, problems. But order is there. So
You are the informant of the case.
Informative. Respondent to the informant.
Sanjay Mehta. Hindustan Kasam. Illegal CG video cassette of the aforesaid picture has come from Mumbai. Since there is an order, let the report come then.
The informant first time. Get a report by fifth. Otherwise, we have to call him.
Lordship. Fifth. Officer in charge,
Okay, just inform. Get the information. So all matter, re-recording of video cases.
Of one movie.
Lordship, interim order may be continued. Right.
It's a leave petition, Lordship. Delay, sir. 11:09, no?
What happened? Other side is present?
Lordship. Petitioner, madam. Petitioner, 49. Jasmine doesn't give up. Jasmine doesn't give up. Oh, Jasmine, I'm looking at this. Jasmine. Tell me.
Yes, Mr. Nasamuddin.
This is a late petition, my lord.
Let's swear in the judgment.
Judgment is an criminal appeal.
Yes. Page number 8.
Criminal appeal. Can accept page number 8.
Yeah, madam.
Section 5.49. Yes. Yes.
No. Okay. Yes. Okay, second one is to put 2%. Oh, that one PW 1% more difference also. That will not be enough. Economic system will continue to be on the same level. It's a down for a few. Second one is to keep one. So,
And go over the time.
It's an appeal of equity. Equity is in. Oh. Huh? Oh, yeah, it's.
Yes, who is appearing for the respondent?
Your lordship, we need some time, the record has been misplaced.
You know that
Respondent
saying,
number one, for respondent number one.
what is the submission? Let her come this side.
Your lordship, we need some time. Actually, the file has been misplaced. So we are not able to.
Nothing upside the first instance. After consuming so much of time now, if you are saying it. What's your good name?
A Parashar.
Yes, Mr. On fifth. Declare the council for the respondent number one. MSA Parasar. List on fifth. Where is sitting, are you?
Where to the 14?
Into the.
My lord, objection already filed, my lord.
Can proceed. Answer, you have a question?
Objection. No question, I don't know, but it's about. Well.
You are appearing for all the accused persons.
No, my lord, I am only for the item 12, my lord.
14. All right, we are in bail.
My lord, in my case, my lord, my conviction was made under section 341, 323, 373, 34, my lord. Basically, I was convicted only due to the common intention, my lord.
Utpal Roy is on bail.
Yes. He is convicted on the 354, my lord, and he was in bail, man.
What about Prafulla Raghav?
Last day, he was appeared.
Who is appearing for Prafulla Raghav? Take your seat.
My lord.
Prafulla Raghav is on bail or not? Not. Okay. Okay. Only Utpal Roy is on bail.
Yes.
Who's appearing, Mr. Busso, you are appearing?
My lord,
Have you gone through the case record?
my lord, not gone through the case record. I've come through the judgment, my lord, and my lord, this testimony of PW1 and PW2, my lord.
Hmm.
In that part, PW2, which is stated in that part
Hmm.
regarding the name of that is the in the item number 12 petitioner. Clearly stated, lordship.
Okay, now just see,
My lord.
move on. You are appearing for whom?
মানে সীমান্ত বড়ুয়া ভাই। My lord, my conviction only based upon that common intention, my lord. Even my lord, during the tip, my lord, I was present, my lord, but the victim failed to identify me, my lord. Though identified some other accused, my lord, but she failed to identify me, my lord.
Involving such a heinous crime,
My lord,
still denying.
my lord, that's a different part, my lord. My presence, my lord, all my
That's a
presence,
different case.
my lord, my presence is called.
That's a different case.
Well, I am not on that whether the rape is committed or not. I am on that.
Take your seats. Take your seats. It is seen from the records of the case that incident occurred on 21/07/2013. The applicant the FIR was lodged on 23/07/2013. Charge sheet of the case was filed on 30/09/2014. And the applicant surrendered before the court on 14/08/2014. And granted session judge going on 22/12/2014 granted bail to the applicant during the trial of the case. Thereafter, in passing of the order of conviction on 16/05/2023, the applicant was taken into custody. And since the order of sentence, 18/05/2023, the petitioner is in the custody serving the sentence. In terms of the interim judgment of conviction and sentence, the theater has a sentence to the. the the state respondent has filed its objection. Ordering the suspension of the sentence and granting bail to the applicant. On perusal of the records of the case and from the evidence of the two victims, this court is of the opinion that the applicant is not entitled the application of the applicant for consideration of suspension of interim sentence, judgment of conviction and sentence. Dated such and such and such. And to grant him bail during pendency of the connected appeal. Cannot be considered at this stage. Accordingly, this application of the applicant appellant, namely such and such, stands rejected.
15, the amicus curiae for the victim. She has made a request. Today is her mother's death anniversary. So she had to leave. She came, but she had to leave. Any day, not today.
On Thursday, my
Thursday.
Thursday, let's see.
29.
Okay, on Thursday.
Not sure.
What?
Please, Your Lordship, as per the service report, office note, Lordship, service is yet to be completed. Upon respondent number 2, we have challenged the conviction order, Lordship. POCSO Act. Lordship, may allow me to take fresh steps in respect of respondent number 2 through the officer in charge.
Yes, take first steps
Yes, through the officer in charge, Lordship.
to the registry,
Through the registry.
to the public prosecutor. Right.
We have to submit a copy to the
On or
registry. They'll give it to us. But I will make it.
Yes, on or before 31st,
Lordship.
list on 26th, 27th.
Lordship, may allow me to take additional steps through the OC because
That you cannot take directly. There is a notification in POCSO matters.
Nice.
The appellant is allowed. This we sought for a report.
Yes, service of
Pragjotishpur
notice.
Police Station.
Pragjotishpur Police Station.
And Mr. B. Sharma was served with a copy. This was on 5th of August. What happened?
B. Sharma. Who is B. Sharma?
Either Bankim Sharma or the other B.
Bidut.
Sharma.
Bidut Sharma. Bankim, who does? Bankim was here. He had to leave for his house. So, no.
Okay, we'll pass the order after some time. Anyway, the petitioner is not here.
Lordship can take it up in that case. Day after tomorrow, we'll also get a report.
Okay, on Thursday. Yes. Have you report now?
No, Lordship, I have not got the report. He is otherwise, he said he'll send it before 2 o'clock.
Swalkusi,
Yes,
okay, on Thursday.
Thursday, Lordship. There was one more aspect. Under section 451, as per our High Court's judgment, things cannot be given in Jimma if it is produced before the court. And it is written in the impugned order that it was produced before the court. That is the reason he could not give the custody. Because that is what is held by the Honorable High Court.
We'll have it on
Police
Thursday.
power on 451, 457, full 457, I think police, 451 court. But if it is produced, then it cannot. It is produced, it is written in the impugned order. As far as the impugned order is concerned, there's it's not bad. There's nothing wrong in it.
You will pass the order on Thursday.
Lodge.
And
I'll
the
look into
information-
that.
And also, both you look into those two provision and also get the information from the Swalkusi
Ah.
police station.
High Court under 482 perhaps will be able to. But then the order is not wrong of the criminal court.
Exactly. But this is criminal revision
This is revision.
on the pair of understand this function. Any information from B Sharma?
No, B Sharma said this is not actually a POXO case. So under the law, we are not required to serve notice through CNO. Anyways, not required at all, not mandatory. Nice. These are under 120B, 468 forgery, criminal conspiracy.
There is an order of the court.
There is an
After
order.
that case, there he was asked.
In certain cases, of course, notices has to be served, which is case of forgery.
See, the court by order dated 2606 call for the scanned copy of the case diary. So in compliance of that, you have to place the case diary.
Case diary is called. Along with it, service report.
Okay.
This is
On
third
ask the OC, otherwise he has to personally appear.
Lordship.
This is an old order.
Forgery case, let him appear, be informant, complainant.
Person to the
What did I call you?
order of the court dated 2606/2024.
Third, no?
The officer in charge of
17.
City School Police Station shall place the scan copy of the scanned legible copy and the updated case diary relating to Prakriti School PS case number 24/2024 corresponding to GR case number 665/2024. On the next step. Based on third. Whatever sentence, failing which court shall consider the cost consequential order against the carrying opposition. Okay. Based on third. Item number 25. 7.
May I please show my lord?
No, confiscation.
Yeah, confiscation.
7. 1 7.
The act is very clear, they cannot confiscate.
This is again confiscation.
May release on any condition.
Confiscation report also I could not gather. Miss Landita Das is working on it, but not received. As a matter of fact, as per law, in fact, confiscation cannot be done before conclusion of the trial. But Lordship wanted to see the report.
That's it.
Have you gone through the records?
Records, Lordship, no.
It's
Nandita Das, in fact, went through it.
Just a minute, there must be some orders.
Two orders I have enclosed, my lord. In page number
Item
60.
number given. Item number one?
Item number 7.
Seven.
Order of 5th September 2023, there is a vote, it is reflected in the page number 64. It is under the process of confiscation, but not.
What is that in the process?
Oh,
yes, yes,
yes, I've got it. Just first, third line. Or here, this is okay, page number 68 of application. 68 of first line of the process. Provider. And police cannot confiscate it. That means there was an error in the UP order.
Miss Jahan, will you able to get the up-to-date information because this is an order of 5th of September 2023. Now, if you come into the order,
Yes, and in the order, it is said that they have already started the process of confiscation. In fact, police report says that it has already been confiscated.
but the order of the court says in the process of confiscation.
In the
Yes.
process.
What has happened basically thereafter, that's why it was
Ah,
rejected at
it-
that stage.
In fact, the police officer was preparing, he will give me within the day or so. Tomorrow, day after, I'll get the report. But was confiscation, how can they give it before conclusion of the trial?
No.
There are so many judgments
Yeah,
on that.
maybe will clarify
Lordship.
and you also places those orders.
Huh.
But what is the stage of the proceeding and what happened with this vehicle? The money has been deposited, that may be in the, after the trial court judgment, they may release the amount or whatever, or maybe confiscated something like this.
Yes,
Get the vehicle, about the information regarding the vehicle.
Lordship. Positively by tomorrow, day after, whenever Lordship desires.
You will have it on third.
Hmm.
You have it in this week itself, you obtain it and place it up before the court on third.
Lordship.
Maybe on, when, madam, 30.
Third,
No, third, or no, on 30 it will be possible.
When do you want?
30th, yeah, 30th,
No, put it on 9,
Friday.
You want on 9th?
on 9, because on,
9 will be Monday. Order matters on Monday, it's difficult.
on 3, the 30th, it cannot be possible, it's not possible on Monday.
Friday it can be
They have to-
done.
on
Lordship.
Friday,
You want when?
on Friday,
Will you able to get it by Friday?
Lordship, they are in the process of making, what she said is that they were preparing and
30, you have many cases, that's the reason.
in fact, my lord, I'm only, I have
Second
been paying till date since to 2022.
Acha.
I'm paying the EMI unnecessary now. There are so many judgments are there.
It will be difficult for you to be here on third.
It's not possible on, I have matter in the divorce of my lord.
When
Second,
will you able to come?
After 5th only, and if
On
not then
5th?
on 3rd.
On 5th?
No, after 5th,
sixth,
After 5th.
yes.
sixth then.
10th?
Mhm.
Will
Tenth.
that do?
It's okay.
Tuesday.
Ms. Jahan, get the order.
Lordship, Lordship.
We pass the order. On 10th, enabling Ms. Jahan.
Yeah, my lord.
Item number 34 on code number 18. Oh, yes.
I believe the lordship.
It seems Mr. Kayal is very urgent. That is why he made it that Mr. Hawk submitted that it should be taken up today itself.
Nothing,
So-
Margot, looks.
He is seeking prayer as well.
Anticipatory bill in NDPS case.
What is the recovery?
3.89 kgs of methamine.
Lordship, that recovery was not from my position, the lordship.
Let us see.
Lordship, and moreover, lordship, in the last till 5th occasions, lordship, CD was called for, but
Lordship, the authority has filed their final complaint today.
Oh.
And sufficient materials is there against the petitioner. Today we filed final complaint against all the accused, including the present petitioner.
lordship, kindly my lordship, in this case, lordship, I was received a notice. Lordship, that notice was case 24.
See paragraph 8 and 9 of this judgment of Supreme Court.
Mr. Kayal,
What's it?
how this person is involved, the petitioner?
Lordship in final complaint is, Lordship may call for the report from the trial court. Today we filed the final complaint. That's, I have informed by the IO that there are sufficient materials against him. Earlier, 4 notices issued to him. First on 26/4, second on 22/5, third on 12/6, and last on 1/7.
He did not appear.
No, he didn't appeal, Lordship. He approached this honorable court. And as per on direction of the honorable Supreme Court, Lordship, interceded in case of NDPS case should not be normally taken up, Lordship.
Which paragraph?
Paragraph 8 and 9, Lordship.
Yes, what do you have to say?
Lordship, in this case, Lordship, my submission is that, Lordship, that I was not involved and no recovery was made against for my possessions. And Lordship, whatever Lordship notice I have issued or I was received, issued by under section 67 of NDPS Act. Lordship, I have annexed one notice, Lordship, in my petitions, Lordship. Lordship, here in this case, Lordship, kindly peruse one thing, Lordship, that here only statement of the co-accused. Someone uttered my name, Lordship. Whether any directly involvement or any recovery is made, Lordship. And moreover, Lordship, whether CD will be reveals that things, Lordship, whether any communication was made by overphone or WhatsApp chat or any other means, Lordship. If nothing has been recovered, Lordship, so NCB, Lordship, several time was directed to produce the CKS diary, Lordship. They did not produce, Lordship. Even moreover, Lordship, they did not file any objections, Lordship, in this case, Lordship. So my submission is that, Lordship, mere statement of the co-accused is not sufficient. Lordship is very much aware to punishing judgment, Lordship. Lordship, that's why, Lordship, I am saying, Lordship, I am innocent, Lordship. Nothing has been recovered, Lordship, or nothing has been any incriminating materials has been recovered, which is connected or which is showing that some connections or nexus is there, Lordship, with me, Lordship. So, Lordship.
Okay.
Lordship, in this regard, Lordship, I submit to one judgment, Lordship. And moreover, Lordship, in this case, Lordship, one co-accused, Lordship, same case, Lordship, same case, same footing, almost same footing. He was got a notice, Lordship, from the NCB, Lordship, and he was protected.
No, Lordship, it is incorrect. Lordship. He was directed to appear before the authority. They appeared, their statement were recorded.
Lordship,
and he also filed his
You have
reply.
submitted the final report today?
Lordship, today for the Court of Sessions.
The final form, final report or final?
So we are filing the complaint under section 36 KPK.
Lordship, in this, that is quick assessment, order, Lordship. And on another assessment I have given, Lordship, the Honorable Apex Court, Lordship. Anticipatory bail was granted, Lordship. And Lordship is very much aware the recent judgment, Lordship. Honorable Supreme Court categorically stated, Lordship.
Okay, sir.
Mr. Hawk,
Lordship.
how many paragraphs you have in your petition?
Lordship.
How many paragraphs?
1 8.
1 8. Third, Mr. I Hawk, counsel appearing for the petitioner. And Mr. S.C.K.L. Standing counsel NCB. For the respondent. This pre-arrest bill application has been filed by the petitioner under section 482 of the BNSS 2023. In NCB crime number 2/2024. That is registered under section 8 within bracket small c /22 within bracket small c /29 of the NDPS Act dated 3/3/2024, in which 3.389 kgs of, you have already the report from the,
Yes, Lordship.
it has been confirmed, it's
Yes,
mathematically.
Lordship.
FSL report you have.
Yes, Lordship.
Metamethapine, METHA, MPHC, TAMine was recovered from one
Devashish Pal.
Devashish Paul. During investigation, the investigating authority agency in the NCB found the involvement of the petitioner, and it is submitted that on 4 occasions, notice under section 67, bracket C of the NDPS within bracket Amendment Act 1985. Issued to the petitioner, he did not appear before the concerned investigating authority. Mr. KL Leonard Standing Counsel NCB relied on the decision of the Honorable Supreme Court in the case of State of Haryana versus Samarth Kumar, SAMARTH. Within bracket, criminal appeal number 1005/2022, bracket close, decided on 20/07/2022. Whereas Mr. Hawk, counsel for the petitioner, relied on the decision of the Honorable Supreme Court in the case of Vijay Singh versus State of Haryana. Dated 17/05/2023. And Manish Sisodia versus Directorate of Enforcement, dated 09/08/2024. Mr. Hawk also relied on a decision of this court in the case of Iftikhar Rahman alias Iftikhar Rahman, IFTA, IFTA versus Union of India, represented by NCB, involved in the NCB case number such and such, being AB number 1440/2024, decided on 18/6/2024. However, on perusal of this petition, it is found that this petition is without any prayer. Which
Lordship,
last page of submission at with paragraph 16, which is only of 2 lines. On being inquired, Mr. Hawk submitted that his petitions ends with 18 paragraphs. How many pages you have in your petition?
that is 7, including affidavit, Lordship.
What is the last page?
The last page is Lordship 25,
The
main petition.
your prayer is in which page?
Lordship, the 6.
Before affidavit of the petitioner, his petition ends at page 6, which is the prayers. However, the petition before the court, before affidavit, as noted above, have only 5 pages with half of para 16, without any further paragraphs and prayer. Register Judicial shall submit its report on or before 38 as to how the authorities in the filing section have accepted this pre-arrest bail application of the petitioner, incomplete pre-arrest bail application of the petition. On or before, Register Judicial such and such and shall submit its report, including the name of the officials concerned involved in this matter. List on 31st.
Much.
Take back your judgments. তোমাক লাগিব নেকি?
Highly applies.
Number 39.
I've gone through the records, as your lordship had said, and I found that, of course, the statement of the witnesses have gone through, and they have, no one of them had stated that he wanted to run away or the scooter was speeding up. Nothing of that sort. What they said is, we were there and we saw the scooter coming and the Maruti car overtaking them.
Apparently, though they are in official duty, but their duty is excess of the
Excess. Now I tried to find out what will be the excess. Now it all depends on the facts and circumstances. One judgment, Matajok Dobe, that I had said on that day, there, of course, it is said that if it is done in excess of the duties and it has an integral connection with the performance of the duty, then in that case it will be covered. But then again, Matajok Dobe, it is said that that can be seen during the trial. So at any stage, I mean, not only required, it has to be in the cognizant state. To any stage, it can be required. So during the trial, the evidence will come, and then if it comes that it is within the excesses, then an excesses is covered. Then it can be taken, the sanction can be taken.
That is the possibility only of trial.
Only on reducing evidence. But one judgment I was just going through, this is also.
Matajak Dubey, just give us the citation, please.
Lordship, this one, Matajak Dobe is the leading old
Yes.
judgment. This is
This is with regard to excess of their jurisdiction.
anything, everything is included there. And Matajak Dobe is it is AIR SC, AIR 1956 SC 44.
Okay.
And there, but another judgment I was going through, there also what happened that this was an official, state government official, he was in duty. And he was ordered to encroach a particular land, whatever encroachment was there, he was supposed to break it down. And then one of the complainant, he had objected to breaking of a demolishing his wall, which was encroaching the public road. And then in that case, what he did, he went inside, the complainant came to him, objected, he went inside his chamber, he was running a pharmacy or something, and then he took his pistol, and then he threatened him, he dragged him out of his office. Those were the facts. And in that case also, they said that it is in excesses, but it was his duty to clear the obstructions, and so he did it. And sanction was stated to be required. This is Lordship will find. This judgment is this judgment Gauri Shankar Prasad. This is 2000 volume 5 SCC 15. 2000 volume 5 SCC 15.
Okay.
This is also a little similar to our facts. Admittedly, this executive engineer or whatever, he is an executive magistrate. He was on duty on that day. His duty was to stop the two-wheelers from coming through that road. And this two-wheeler went through. And then he stopped the vehicle. But then he pointed the gun and he abused him. He had also held him by his neck. And of course, tearing the chain and all is not there in 161. The witnesses have said that I have not seen him taking out the chain. But other things, I mean, holding him by neck, abusing him, using the pistol and pointing him on his chest, those are there. Now, whether that will come within the excesses, which has integral connection with the performance of duty. That is the relevant question to be seen. But this judgment of Gauri Shankar Prasad somewhat is similar, and because everything depends on facts. Matajak Dobe, those income tax officials, they had assaulted the securities. Those judgments are there.
We'll look into it.
Lordship. But otherwise, fleeing away, trying to run away is not there. And at any stage, as Matajak Dobe had said, Lordship can give a finding on that also.
It's only matter relates to whether sanction will be required.
Yes.
That much only here.
Yeah, they proceeded without the sanction. Shankara Moitra also knows, Lordship, that the election was going on and the husband was distributing fruits, and then there was a chaos, police came, had to fire, and the husband died in order to control the chaos.
That will be not only in the access of jurisdiction, because already there was some incident. It will be in the name of Panchali Bhachaji or what?
Yes, Lordship.
Pardon myself. Also referring for the and I must have order in the
Obliged.
In this criminal appeal, my lord, the two connected appeal, what I have found, my lord. In this case, my lord, the police officer was convicted and his conviction is based upon one exhibit, my lord, by the trial court. There is no other evidence, only basis of one exhibit, that is exhibit 2. That is the finding of the trial court in page 70. Lordship will find the whole case is based on that exhibit. There is no oral evidence to that effect. He was the police officer accompanying the deceased, my lord, in the leading to discovery, my lord, process. When the victim died in that process by drowning in a pond, my lord. Then now, admittedly, my lord, in the trial court judgment, whole conviction is based on one report, that is exhibit 2. Now that I've gone through, my lord, in the LCR file, the exhibit 2 is not there. My junior has checked it out today morning, but the exhibit 2 is missing, my lord. That is the
The judgment, what it has been stated, with regard
Yes.
to exhibit 2.
Page 70, my lord. In our page 54. I know 70.
The judgment page 54.
54.
Yes.
From the first. From the first progress report, exhibit 2, and the final progress report, it appears that the accused Nakibur Rahman inflicted the injury on the head of the deceased. However, the first and final progress report were submitted on the basis of investigation done by the investigating officer. The eyewitness have failed to identify specifically who inflicted injury on the deceased. From the GD entries and the evidence as discussed earlier, the presence of accused Fanidhar Bora, Ranjit Nayak, Nur Islam, and others are established. Fanidhar was as the aside of the police and he leaded the police party and the victim to the pond. His leadership deceased was assaulted, even if he did not inflicted injury to him. From the evidence of eyewitnesses, it appears that Fanidhar Bora and others did not restrain the assailants from inflicting injuries to the victim. Fanidhar Bora was the superior rank in the all other officers, we had so and so, so and so. So this is the one of next, Lordship kindly see page 73. Hello? Page 72, man.
Just a minute, Mr. Yes, next page.
My lord,
72.
72, my lord,
Oh.
paragraph, my lord, 80.
Hmm.
Here is a case accused Nakibi Rahman has only been charged with the offense committing 302 IPC code. Accused Nakibi Rahman as a police constable, the victim taken to the pawn by the Fanidar Bora SI police, accused Nakibi Rahman, Ranjit Neok, Srinath Pathak, Bhupen Bora, Nur Islam. From the progress report, as discussed earlier, it appears that during the investigation, it was found that the accused Nakibur Rahman has inflicted injuries to the victim. However, the eyewitnesses could not identify who amongst the police personnel inflicted the injury to the victim, which ultimately resulted in the death of the deceased. Fanidar Bora was the superior officers amongst the other personnel. None of the accused person has disclosed who inflicted the injury to the victim. The fact remains that the victim sustained the antemortem injuries which caused his death. The presence of the accused person has been proved. Nur Islam was the driver of the vehicle and the Ranjit Naik was the police constable. From the documentary evidence as well as the oral evidence, I found the accused Ranjit Naik and Nur Islam and the Islam neither did any overtake nor which they can be convicted on 304 I4, nor any common intention has been revealed against it. Fanidar Bora was the head amongst the police personnel. In his guidance, the victim was compelled to enter into the pond and was assaulted by the police. The documentary evidence as well as the FIR shows that Nakibur woman caused the injuries to the victim. So, my lord, the documentary evidence, that is the exhibit 1 and 2. So, on the basis of that progress report, my lord, he was convicted. Admittedly, there is no other witnesses, oral testimonies against the person, my lord, appellant. On the basis of exhibit 1 and 2. Progress report.
Ms. Zahan, probably you should go to the records.
No, I've not gone through.
You have not gone through.
I've not gone through. And what he's saying that those documents are not there. Exhibit 1 and 2. There are 11 files, but
In the morning today, we tried to find it out, my juniors, but probably it is not there. There's an exhibit file itself on that.
You are appearing for Nakibur Rahman.
I am appearing on Nakibur Rahman. And there's another connected appeal, my lord. My learned friend is appearing on behalf
Mr.
of.
Fukan, you are appearing for Nur Islam and 2 others. Nur Islam, then
Nur Islam, Srinath Pathak, Bhupen Bora and Ranjit Naik. Nur Islam was the driver, Srinath constable, Bhupen Bora constable and Ranjit Naik PSI.
Evidence of
Twenty-seven acres and 77 হবে সিদ্ধি কেমন হ্যাঁ মনে না বলো এগুলো হ্যাঁ তুমি কবে এখন খেলে নিয়ে আছে এটা Oh, I will legal contract to some extent. People reasons no very disaster and all. Yeah. Look at this. When you stage disaster, right? এটা হয় কিন্তু এটা old and new. হ্যাঁ এটা কন্টিনিউ করতে হবে
revisit করা যেতে পারে কিন্তু একটু
There are judgments, no such don't do.
সেটা আমার লাগে সেটা একটু revisit করবেন এরকম ডিসাইড অন দি বেসিস অফ দি
Not that the heat can be charged.
No, not that way. I have a bit. I didn't even have the copy. Lordship can give us some time. I've taken a copy from him now. So I'll go through. All matters our office people disposes it of perhaps.
But one of the accused expired, right?
Two, my lord.
Fonidhar Bora expired, and who else?
Will expire also.
Fonidhar Bora did not prefer any appeal, that appeal might have been abated, that's why it's not before us.
Kumud Chetia, my lord, and Fonidhar Bora.
They are not before us. Their appeal, if any, has been
Probably already disposed of, probably, maybe.
because of everything.
There are 7 people, no?
Could be difficult. You have verified, it's not available.
There is an exhibit file itself, my lord.
Whether that is legally admissible evidence, no, the progress report. That's some communication between the. Yeah.
Leading to discovery.
Oh. Am I being kissed? और भांडे पुलिस वालों There are 5 persons convicted, no?
Altogether 7, সেটা দুজন ঢুকালে। কুমুদ চেতিয়া, ফণীধৰ বৰাটো লিখিত ইহঁত দুজন ঢুকালে।
কুমুদ চেতিয়া expired.
Expired.
ফণীধৰ expired.
Expired.
আৰু
এতিয়া বাকী 7জন আছে, নেকিবুল আছে,
নেকিবুল
ৰঞ্জিত নেওগ, নুৰ ইছলাম, শ্ৰীনাথ পাঠক, ভূপেন বৰা।
এই 4জনৰ কাৰণে তেওঁ আছে। From 304 to 304 part 2.
Take your seat, sir.
अच्छा
What was the injury?
My lord, exhibit, as per the exhibit 1 and 2. 1 probably the GD entry, 2 is the progress report.
Doctor drowning.
What was the, that exhibit?
My lord.
Exhibit two, you say?
Two, my lord, basically. One probably the GD entry, maybe. And this two is the progress report as per the judgment is concerned, my lord. No?
In those cases, what is happened? Because there are so many things that are things,
Prosecuted without. Person is prosecuted, the function is required, but is prosecuted without. I think this sanction language, page to sanction item, give us start.
Dinner to start coming.
I'm helping one. Usually, I'm
That's a good point to then brought late in the prosecution.
Wait in the prosecution, but it took one and a half hours to start. That means no matter wait in the prosecution, but you bring it from the head. But Sanction of conflict is not here, what particularly issue by.
On that basis.
On that basis, we Sanction of what is.
No, this one.
My body is now on the sanction. Good sanction. Even when there are stuff. You have to do. You said progress report and GD entry is not available.
Yes, sir.
Yeah, I was taking. Documents. This one, I know.
This concept of the progress report is really awesome. This is progress report. If you repeat each conviction, it shall be progress.
You're not taking the records. You're separate.
Or exhibit to issue.
You do it between. Okay.
As per the index, it's there, but correct.
My lord?
As per the index, it is there.
Yes, yes. Index it is there. Maybe in the case diary, I don't know, madam.
Is there is very small. Ms. Jahan,
Not.
you have to work out.
Yes, yes, got it. I'll look into this.
Because you was convicted on the basis of that progress report itself. Otherwise, it's without progress report also, madam, I have a case that cannot be basis of conviction, madam. On the basis of report, absolutely not permissible, madam. Otherwise, my lord, everybody can be convicted on the basis of a charge sheet itself. Charge sheet also in a report. Law is settled, but the still, my lord.
I don't know how come it is.
I'll look into lordship.
It's not.
Because on a progress report, if a conviction is given, it is little bizarre. I mean, cannot withstand. But I'll go to the entire facts.
Oh. You'll not get it.
You, ma'am.
There are reasons.
It's a total making out.
Those are in police custody.
He was in police custody, huh?
The GD entry and the progress report
Huh.
are in police custody.
Oh.
Just for your sake, we have just.
Police custody means they have to keep it in the records. I mean.
It is not there. Just see.
Acha, acha.
Mr. Bora, just second look. On the right hand side, there is a column.
Yes, police custody, yeah.
GD entry,
First
police
progress
custody.
report.
Then exhibit 2 down below,
Yes,
police custody.
yes,
That is why it is not available here.
yes.
GD entry A2 police custody in police custody remark. A2, sir? A2.
We have the court records. Okay.
What will they do with the records? I mean, they have to give it to the court. What will they do with these?
GD entry records, I don't know, how come it in police custody?
Ah,
Of course,
this is-
entire case there is not before us,
Acha.
but a part of.
After exhibit, how it is, I don't know, how it is been exhibited in the court and how.
Part Mr. A. Bora. counsel for the appellant in criminal appeal number 98 of the 20. And Mr. DC Leonard Senior Counsel, assisted by Mr. Such.
D Chaudhary.
And Mr. DCC Fukan, Leonard Counsel for the appellants in criminal appeal number
Police custody क्या चल रहा है?
103 of the 2000. Mr. Bora Leonard Senior Counsel submitted by placing the impugned judgment of conviction and sentence.
এইবোৰ আছে।
Dated 02/05/2011. Caused by Leonard Sessions Judge.
মানে? Oh.
In Sessions case number 93 and dated JJ. Of the 2000.
কেলে আকৌ recovery
Reference here case number 162 of the 1999.
এই medical evidence and liberation given to us.
Case number 17 of the 1995.
So many of them have taken.
Submitted that.
Convicted on the basis of
The conviction of the appellant herein of the progress report with her.
during investigation progressive
Are on the basis of
conviction.
Imagine. জোর গোষ্ঠী দিছে।
the entry,
মানুহবোৰ ভাল সঁচাকৈ নেই।
the 11 police case and the progress report submitted by police.
Leading to recovery.
Mr. Bora also submitted. Leonard Senior Counsel that exhibit 1, exhibit 1, and progress report exhibit 1. But neither the GD entry book exhibit 1 nor the first progress report submitted by police Memorial NDPS case number variety are available
গোটেই পুলিশ ডায়েৰীখন ক্ৰছ কৰিলে হ'ব।
in the case record. You have to exhibit on, sir.
Reinvestigation director. Reinvestigation.
During verification of the records of the case relating to the case number 93 2000. They seen in the remark column of the exhibits file inside 93, inside sessions case number 93 JJ 2000 that GD entry exhibit 1 that's GD entry book, yes, volume Roman 12 Morioni Police Station containing GD entry numbers 0892 GD entry number 117. As well as GD entry number 648 dated 20/08/1994 and the signature of Sri Kumud Setia are in police custody. Similarly, exhibit 2, the first progress report with the 11 signature are also in the police custody. So now who shall give it to you?
Hmm?
Who shall give it to you?
I'll write it to the police officer. And a case diary will do. Perhaps Lordship had said that it's a small one. If the entire case diary comes,
It's a very small case diary that we have seen.
once it is exhibited, it again went back. This is also surprising. Original बोलने के photocopy तो सही बोले उसे. Oh, fine. 95. Papers belong to the year 95, I'm told.
Just a minute. There is inquiry report.
क्यों बोल? For some purpose. First for it, report a conviction, that needs to be seen, no? Okay, too. Something very. प्रारंभ तो ऐसे इंडेक्स टू द डेफलो एक घंटे डेफलो exhibit question.
What is the date of the incident? Mr. Bora, while looking at it, have you, that order of the Lanet Trial Court of something, the progress report? Do you
Yes,
have a
sir.
date? By which order it was directed to have the progress?
No,
report?
but probably it was during investigation, my lord. Date of incident is 25/8/1994.
No, there is an order from the court for further investigation.
Yes, yes. There is an order for the court and they have re-investigation also, my lord. Dated 29/5/1998.
No, it had it been from knowledge, there has to be
Well, that,
exhibit or seen it from original, something would have been there.
yes. Well, may I have the date, my lord, on which that list of exhibit was prepared, my lord?
No, admitted is there. But thing is this, that will not help us to find out the document, no?
Yes, sir. Who
That
prepared
thing is
that, my lord, list, my lord?
Is there? Date of admission is, the exhibit one is 25th of August 2003. And the exhibit two is 15th of October 2004. It was placed by prosecution.
Yes, that means those exhibit are definitely before the court at the time. And thereafter this list was prepared. After conviction. Because all those documents after the exhibits, it's become a part of the court, my lord.
How come they suspended it in custody of police?
Yes, ma'am, that's the very peculiar circumstances. Become a custodial legis, how come it can go back, ma'am?
It's not available here. How to get those, Miss Jahan?
Lordship, that is the difficulty. I'll write it to the concerned police station. I'll tell them to see and find out.
Matter was handed over to the CID Assam.
Yes, yes. Initially, investigation done was by the Moriani.
Because Moreni police has submitted in the final form, no, final report. Second. So that is why then after the further investigation.
Yes, second charge sheet was filed by the CID.
But there is nothing on record that the.
No, it is
How you get it, Miss Jahan?
The only way is to write it to the concerned police station.
Police station will not have it. It should be only by the CBI now, CID.
But police or CID? No, I mean,
Yes.
it is in police
CID.
custody. No?
CID Lawrence, subsequently investigation was taken by the CID.
Achha.
On the basis of the court order.
Hmm.
First charge sheet was filed on 29/5/1998. Second charge sheet was filed subsequently by the CID on the basis of the re-investigation or the further investigation, whatever.
It was date to issue 29/3/2000.
29/3/2000. Second charge sheet.
Went to the CID office.
Case diary was returned from the court. Then. That of course 95, not before. You go to the records, but what order will pass today? The CID case was registered or same on the Moriani police case it was considered?
Same, same. Only the investigation was handed over.
I was an observer, retired.
He জানি কবে নহলে কোচ যাবো এটা রমেশ চন্দ্র দেখা হলো PW26
How to get it? CID লিখিব লাগিব আৰু।
SP Jorhat to be directed to forward the findings. That will do. Will enter the SP Jorhat to first. In PhD. The Police. District Jorhat.
Or the CID personnel. SP Jorhat might say it is with the CID.
See, after the order of the court, if you come to. You have the copy of the judgment with you.
Yes.
Page, internal page 21 of the judgment.
Okay. Yes. 21.
Page 21, para 33.
Paragraph? Oh,
33.
Yes, paragraph 33. He was the circle inspector. During his tenure, CID came for investigation. He asked for certified copy of the first progress report submitted by Kriti. Accordingly, CW5 furnished a certified copy of the documents. His first copy, these are certified copy of the documents. Copy of final progress report submitted by the then CI. On Iman, certified copy of GD entry, total 5 copies. CID inspector. These are all certified copies, secondary evidence. So, what check?
In cross-examination, he admitted GD remains.
In cross-examination, he admitted GD remains in the custody of the circle officer. Circle officer only अपना सर. वो नहीं दिया. After conviction वाले वाला पठाई थी आशा था. Itu sama baik.
On which date that list was dated, that exhibit,
Which date it was exhibited?
No,
That
that
list.
list was prepared, exhibit.
Where it is shown, it is in the custody.
Index, madam.
4607.
4607. What is this for conviction? Yes, this is 2011. It is before conviction. Perhaps the remarks are of a later date.
It will be. No, on 15/10/64, additional session judge.
15?
10/64. And finally, list was prepared, the list of exhibits. List of exhibits, because it was part by part. After recording of evidence.
My lord.
It was part by part, various judges have recorded the evidence.
Okay.
So the exhibits were placed on different dates.
Then finally,
Starting from 25th of August 2003. And ultimately, last document was placed probably. Was on. 15th of July 2010. So from 2004, 2003, August 2003 to
Up to
2010.
2010.
Trial went
Various
on.
trial continued and various documents are exhibited. Thereafter, my lord, after conviction, session judge also has to prepare a list of exhibits, my lord, along with the
That
judgment.
normally we see in the judgment itself, no?
Yes,
Last page.
Whether it is available or not. doesn't
no,
matter.
not in this
Let
particular.
us see the original judgment. Let us see the original judgment. Yes.
Hmm?
It's not available.
Last page is not there.
List of exhibits. Must
Must
be
be
there
there.
in the main final judgment.
Yes.
It is not there. But that will be only technical flaw in that case.
Yes. But only, my case is that only basis of those two exhibits he is convicted, my lord.
And those two exhibits are not there. Now, when it went to police custody, this is also not clear. Whether after evidence or during.
Just a minute. They're somewhere else now. Justice Indira Shah, Justice P.K. Sekia, who else? Not all, but. Fifth of August.
Another one, they have taken certified copy from the circle officer. I know. Circle officer is a one. Circle officer is a only.
ASI Poniborai, Sorikula Mitro Content as a ED cases of raised.
Progress report is of 13th of March 1995.
Yes.
Yes, 1995.
A घटना हम के डिपार्टमेंट और
First progress
Minister inquiry.
डिपार्टमेंट और इंक्वायरी वेलर करेगा
Ah.
एसपी महोदय सुपरवाइज कोई नहीं देख दी ए में नो सुपरवाइज कोई फास्ट रिपोर्ट देखो करो
Even circle officer.
নহয় ইটি সামনে গুগল
Here circle.
এই হলো
Circle inspector.
সরকার ইন্সপেক্টর এখন তার প্রোগ্রেস রিপোর্ট একটু হেরিয়ে না
Tire progress report. It will be with him only.
এটা শুধু এক্সিবিট করলে না কেন কাহিল হয়ে যাবে ফার্স্ট প্রোগ্রেস রিপোর্ট
13,395.
সামনে আগে দুশো রোজ করে দিওতা নির্দক্তি এই মনে নয় এজাহার দিব সো দিস প্রোগ্রেস রিপোর্ট ইজ প্রায়র টু দি এফআইআর
No, prior to DF, after magistrate inquiry.
এখনো উপরে কনভিকশন
It is prior to FIR. Officer FIR is.
18,295 সেকেন্ড এখন পদক্ষেপ 2 ফার্স্ট প্রোগ্রেস রিপোর্ট 13,3 আর এইটো হল 18,295 একমাহ আগতে দিছে এফআইআর আগতে দিছে তাৰপিছত এটা প্ৰগ্ৰেছ ৰিপোৰ্ট দিছে
After progress report after 1 month.
But this is before the case is handed over to the CID, I believe.
No, this is before. Because it was initially raised
just
as
within a month of the FIR madam.
Hmm.
FIR was lodged on 18,295 and this first progress report my lord 13,395.
I think this is the report.
Session will be okay. Could go to exhibit also. Inquiry go. No.
It's a little like this. We are Sub-Inspector of Police Khogen Bormon, Morini Police Station. He wrote a letter to the Superintendent of Police Jorhat. I have the honor to report in connection with above noted case. A magistrate inquiry was made by the Additional District Magistrate Jorhat, Sri Bipul Sharma, on 20/06/1994. And the records of inquiry report is now in your custody in record room. But a report of the relevant documentary evidence of the case and the statement of the witnesses by ADM Jorhat is the records. So the record is required in connection with the case of documentary material evidence of the case. I therefore pray that Your Honor, that a necessary order may kindly be proposed to be collected some records to take necessary action and such. This is a letter of 10th of November 1995. And that report, inquiry report, whether you call it progress report or whatever, it was submitted by the B. Sharma, Additional District Magistrate. There is a photocopy of it. Maybe that is the progress report, it seems.
Whether that is exhibited, madam,
No, this is a photocopy,
but no exhibit, madam.
but there is no seal, nothing. Then there's the letter from the reader, Sub-Inspector Superintendent of Police Office, Jorhat. Superintendent of Police, Jorhat. Now, it is like this. OC Moriani Police Station. The investigating officer of the above noted case was asked to take the follow-up action by the Additional Superintendent of Police Headquarters, Jorhat, by this office number such and such. Please confirm whether the IO has complied with the instructions, but that is a different issue altogether.
But the,
But this particular progress report, who was the PW 13?
well, he is the
Circle
Kirti Chandra
inspector.
Gogoi.
No circle inspector.
He is a,
But he did not submit this report. It was the subject of some Sharma, B. Sharma.
but the, as per his evidence,
No.
he said, my lord, the SP মহোদয় গোচৰ supervise কৰিবলৈ মোক নিৰ্দেশ দিয়ে এই মই supervise কৰি first progress report দাখিল কৰোঁ প্ৰদৰ্শক 2 first progress report dated 13/3/95
So progress report and inquiry report are same.
আৰু এখন বেলেগ এখনো আছে magistrate inquiry report
Ministerial inquiry is
which is different
separate. Departmental inquiry it also. So progress report money?
কি এখন progress report দিছে
Inquiry report any?
সেইটো magistrate বেলেগ এখন magistrate এখন আছে এখন exhibit হোৱা নাই এখন নাই ৰেকৰ্ড
That's not available. That's not available. The statements are here. Inquest report is there. What is that? I said that number. GI. GD entry, GD entry.
GD entry, madam.
Exhibit 1.
Yes, it has to be exhibit 1.
What is the number?
I don't have the GD entry also.
Number 64. It is as GD entry number 64 media.
Judgment will also be.
No, it was GD entry number 64 is a question. Or over total 5 copies which were seized by going to exhibit 14 it will. Final progress report, certified copy of GD entry.
CW5, the certificate for the first photocopy final progress report submitted by CI, Dr. Pujanan, certified copy of the GD entry number 64.
You circle inspector. CW, Satyendra Patoi.
What is this? Kumud Chandra? Who submitted it?
GD entry, madam?
No, that report was submitted progress report.
Kirti, PW 13.
Name again?
Kirti Chandra Gogoi. PW 13.
No, it's not available. It's not available here. What to do? Who will give SP or what? Ms. Jahan, you direct someone, you have to direct someone.
Since it was exhibited, after exhibiting documents, it cannot go somewhere else. So let the session just make an inquiry.
But it is in the exhibits, it is clearly mentioned, it is in the custody of police. In
No,
police
that was
custody.
when.
That was probably prior to the, my lord,
Judgment, no. No.
prior.
But something would have been there in the record, no?
Hmm.
And how it has been exhibited, they have exhibited definitely, my lord. If once they have exhibited, it has to be in the session judge, my lord.
Now, we have the starts here, the FIR by K.T. Chandra Gogoi. Then it starts with the postmortem report. The other documents, of course, confirm. It starts with exhibit 3.
Yes. So till 2004, it was in the custody of the court, madam. It was exhibited in 2004.
It was exhibited in 2000.
My lord, it is exact date was 15/10/2004. He was examined on that particular day when he has exhibited, my lord.
He lasted like the United Sessions of Jorhat.
Yes, sir, and another 19 documents including general diary has been exhibited.
And 2.
Handcuff rope also.
Are not available. Yeah, exhibits fine.
Conviction,
Ms. Zahan, you want
Lordship?
you also go to the records. To know
yes.
that whenever you want it, before signing this order, at least you verify, it may be available, which you could not trace out. May so happen.
I'll do it now.
It will be better for you to go to it and then, because it's a very old case.
Index.
He has convicted on the basis of that document, and that document itself is mixing. Very surprising.
It's an old case, that may be the reason.
How it has, it was exhibited. And he has not prepared the list also. Otherwise, that has no value at all, madam. As far as law is concerned, madam. If my learned friend resides on, that's a different issue, madam.
If on that, Or you can place on the other, thing is just the other side, that on the basis of that. It
Yes.
cannot be convicted.
Yeah,
On the basis of
that I cannot defend, of course. That cannot be. On progress report, GD entry. And those are the two documents which are missing. Otherwise, all others are there.
It may be available, you know, what we have found is that there are two files of exhibits. But the second file of exhibit contains only order sheets.
Oh,
Even if it is there also, my lord, my case is that that cannot be the basis of the conviction. That's a settled proposition of the law, my lord.
I'll check the records and we both will check the records now.
Thursday, shall we fix it?
Thursday is 29th.
My lord,
Okay.
Then we'll not,
let him check it first,
हाँ,
my lord, then on
Exam
29th.
Assistant Public Prosecutor is
We just check.
is allowed to go to the records. প্রথমটাই লিখিবে লাস্টের অর্ডার লিখে দিলে তোমরা এক্সিবিট 1 ইনফো নাম্বার লিখবে means down addition and procedure is allowed to go list on
Obligation.
নাটিবা মেনশন করছিলে বিলিং মাত্র
But it's seeking quick stamp, Lordship. Our file is misplaced from our chamber.
which item
Item 20 and 21.
we are not taking that item 22
22. So possible for that.
these are 2013 meters why you are asking for password you are there could give a try
22. Chambers matter.
who is appearing
Actually, I'm not contacting advocate in this case. Mr. A. Ahmed is contacting advocate of item 22, Lordship.
on bail right
My lord, bail আছে নি?
22, I don't know about.
password Learned Session Judge Borpeta in Sessions case number 43/2009. Reference GR case number 310/2007. Then dash triple PRC case number 249/2008. Arising out of Borpeta Road Police Station case number 59/2007. By judgment dated 20/02/2013. Convicted the appellant under section 497 IPC. 497/498 IPC. And sentence him with rigorous imprisonment for 3 years. With fine of ₹2,000 in default of payment of fine to undergo further simple imprisonment for 3 months. under section 497 IPC. And further, to undergo rigorous imprisonment for 1 year with fine of rupees 1,000 for the offence under section 498 IPC. For the offence of in default of payment of fine, further simple imprisonment for 1 month under the for the offence under section 498 IPC. Observing that the period of detention in jail, if any, underwent by the convict during the period of investigation, inquiry, or trial. The setting of the period of detention, setting of the period of detention in jail, if any, under such and such and such, against the terms of imprisonment imposed on him. Aggrieved, the convicted accused preferred this appeal, which was admitted way back on 05/04/2013. The relevant records from the relevant trial course record was called. And another application of the appellant being criminal miscase number 179/2013 filed in this criminal appeal. The court by order dated 05/04/2013 suspended the impugned judgment and order dated such and such passing said sessions case number 43/2009 by the learned session judge Borpeta and allowed the appellant to remain on previous bail until further order. Though this case is pending for adjudication since 2013, but it is seen that on last 2 occasions, the counsel for the appellant remained absent. Placed on 5th, failure on the part of the if the appellant remains unrepresented on that day, court shall consider to pass an appropriate order.
Please, Honor. Yeah, my client entire money has been received, Lordship. So kindly matter be withdrawn, Lordship. But
What are the
instruction of my
documents?
senior Lordship.
What are the documents?
Documents
that
has
you
not
have said
received
in the
by the-
morning.
Documents has to be opposite side. The opposite side has not been appeared till that, Lordship.
Your mayor submission will not do.
Exact kindly fixed, Lordship. I will file affidavit, Lordship.
That is not the way you file an affidavit. Where anybody can come and say,
Not received.
the accused Nonibala Deka was acquitted.
Yes, Lordship.
Then what is your prayer? Your
I am
for
I am appeal for a judgment against equity, lordship.
So what is your prayer now? Want to pursue this matter or no?
No, lordship, my client is taken instruction from my client, but she is going to say my money is received. So next that kindly fix for I submit any document.
She has received the amount.
Yes, lordship.
Where is that document? It will be with your
Documents-
client only.
Documents.
The accused Nonimala Deka was acquitted
Yes, lordship.
and she was supposed to pay you,
Yes, lordship.
right? Now, since the accused is acquitted, aggrieved, you have filed this appeal
Yes.
against acquittal.
Yeah.
Now, when did you receive that amount?
Receipt, next that I will be furnished, lordship.
Third, or on 29th, you can give it to us.
29. Yes, lordship, I will.
Okay, on third, it is submitted by the appellant. This appeal, this is an appeal against acquittal. During the deliberation of the matter, what's your good name?
And Borua, lordship.
Counsel for the appellant. Full name?
Yanjan Borua.
Submitted that the appellant complainant has already received the 11 amount from the acquitted accused sole respondent. However, the learned counsel for the appellant could not place any material in that regard. Or you don't want to pursue this appeal, we'll pass that order. We'll finish it, close it. Up to you.
Yes, I think 29 I will be furnished any document.
On the prayer of such and such list again on 29. First order, 29, will you put it on my prayer? Yes.
Last Mr. Ajad is not available in court, lordship. Item.
What is this? You are on bail and this is not fair. Now you are there in this case.
I am not in the case, lordship, Mr. Ajad. And I have become sir.
Tell us what to do. On last occasion also you have taken time. Tell us. Generally you can think about. It's a case of 376. And since the accused in bail,
My lord.
as you know, the prosecutor's statement will be enough. There is no other, and he was caught red-handed by public, the villagers. So what will you do next time? We'll recall the bail order. None appeared for the appellant on court. The appellant is on bail. He is a convicted accused under section 376 of the 448 IPC. Relating to an incident that occurred 10/4/2009. If the appellant remains unrepresented the next day, fixed, the court shall recall the bail order. Based on. Given money at people allowance and.
26.
No representation on behalf of the appellant on call. Or Mr. K. Bush. The appellant is a convicted accused under section 326, I think. Under section 326. Of the IPC. And it on bail. This Thompson will be. Maybe petitioner at the appellant could so consider to recall the bail order. Uta, matam, really apne.
My lord, item number 33, my lord, there is a IA for 389, my lord. Kindly, direction may be given to list the matter, my lord, for in order column.
Item number 33.
33, last second.
Criminal offense 3532023.
Yes.
It's been wrongly listed.
Wrongly listed, my lord, in hearing column. It may be listed on order column because.
Why,
my
Mr.
lord,
Borman? Why your bail application is pending or what?
Bill is pending.
Okay. 33 Nicolai. Criminal offense 3532023, which IA 892202. List on 10 for orders.
Lord, item number 29, there is an interim order. There may kindly be something.
Criminal petition.
The interim order is there already. Till today. That may be kindly continued. Earlier, there is a continuation of interim order.
Lordship, item number 32, it is a maintenance matter. Taking advantage of the interim order passed by this Honorable High Court, husband had stopped payment of the interim amount before the learned family court. So the wife respondent is suffering lot.
These matters are, when it was decided? When it was decided?
It was decided way back in 18. by the Learned Family Court, Guwahati, Your Honor.
But you have
So
filed, the
it
appeal
may be
was-
listed in the 29th or 30th of this week, Lordship.
But it was filed only in 2023.
23, of course. That is an execution matter. By doing this revision, execution is being stalled, Your Honor. Even interim order is not respected by the husband or petitioner.
Then we'll get it in the order column,
Yes, maybe in the order column, yes.
item 32.
Yes, 32.
Lordship, interim may be continued till then. I am for the petitioner, Lordship.
They are taking advantage of interim, but they are not depositing the amount regularly, Lordship.
You just tell us on 5th, since when he is not the,
Yes, yes.
not complying.
On 5th, it may be listed, Your Honor.
Kindly place the relevant records that he is not complying since the order of interim order of the court.
Yes, yes.
Place us, will vacate the interim order.
They
But you have
keep
to place
it
certain
accumulated for
documents.
2-3 months. Thereafter, only paid for 1 month, Your Honor. That
Obtain
is the regularity they are doing, Your Honor.
Obtain the certified copies from the concerned court. We'll see to that he has not complied with. We'll vacate the stay order.
Yes, yes.
You
That
heard-
in, that in may be listed
if
on
you-
29 or 30.
Not possible. We'll have.
Then next week, Lordship,
5th.
or 5th, yes.
Obliged, Lordship.
Obliged.
We continuation first, second.
12 শুনিছো আপুনি 3 ন যে গলো
বারো শুনিছো, 3
Okay.